Good morning, everybody, and welcome to My Deposit's very own first webinar. Today we are going to talk about a few different things, but before we start on the content, I just want to remind you that you can submit questions while the webinar is on. We've provided you with a screenshot on the left-hand side of the screen. You'll be able to see where the question mark is on your screen, and you'll be able to let us have some questions as we go. If we don't get round to answering everybody's questions, we will follow up after the webinar and respond to you as soon as we can. And just to let you know, this webinar is being recorded, and you will receive a copy of the webinar after we close. So what are we going to talk about today? Well, our journey today takes a look at some of the new rules, some of the old faithful documents that we need, and some of the changes that lie ahead that arguably may or may not affect disputes, which is obviously one of the things that I specialise in. So we're going to look at some of the old, some of the new. We're going to look at holding deposits and deposits. The tenant fee ban has had an impact on the market, as I'm sure you all know from reading the property press. We deal with holding deposits as part of our complaints through the property redress scheme, and it's often the most common queried complaint, which we are usually able to resolve pretty quickly. We're going to look at deposits, which are also affected by the Tenant Fees Act, as well as looking at the new alternative products which are evolving in the market. I'm then going to move on to talk about tenancy agreements, the old faithful documents, and the check-in and check-out inventories, and see if they've had any impact from past to present and future. Then I'm going to look at what lies ahead, what we know is coming, what's in the news at the moment, and just give you a flavour of what our content might look at in the future. Please remember to ask your questions as we go if you have any, and we can also look at answering any questions if we have time at the end of this session. So let's take holding deposits as our first topic. Defining a holding deposit is quite simple, really. It's something a tenant pays to the landlord or the agent to reserve the property. The Tenant Fee Ban the Tenant Fees Act has laid down very strict rules in regard to holding deposits, and so I thought we'd look at this in a bit more detail. Very often the question is, how much can you take? And the answer is very simple. You can take up to 1 week's rent as a holding deposit. The way to work that out is to multiply your monthly rent out by 12 and divide that by 52 weeks in the year. Now, at the end of the day, the legislation is quite clear. You should really consider whether you even need to take a holding deposit. The next question is, when should you take the holding deposit? Now, the legislation again is very clear. The government guidance is very clear. You should only take it after you have given the tenant clear information on why you are taking it, the reasons why you may not refund it. So that you need to make it clear to the tenant what they have to do to make sure they get their holding deposit back. You need to make clear the amount of any deposits you're going to take, what their rent will be, and really important, you need to provide them with a draft tenancy agreement before you take that holding deposit. They need to clearly know what their responsibilities will be under your tenancy, as well as carrying out some basic checks. The other thing you will need to know is that you will need to agree a specified date for reaching or starting the tenancy. This is called the 15-day deadline agreement. That's the default time that you should be able to do all your checks and start the tenancy. You can vary this time by mutually agreeing it with your tenant, But if there's no mutual agreement and it doesn't start within that 15 days, then you will have to refund the holding deposit if that's what the tenant wants. It's really important not to waste a tenant's time when you've taken that holding deposit. You need to be well on your way to starting that tenancy. And it's really important to realise that you can only take one holding deposit per property. So if you have a shared property, you can take one holding deposit from one, or you can split the holding deposit between the sharers. So that's what you have to do before you take a holding deposit. So now let's look at what you should do after. The first thing you should do is stop advertising the property. Because you've taken one holding deposit, you've done all the basic checks, and there's no reason for it not to continue. What you will want to do is carry out further checks, such as your referencing and right to rent, if that's a necessary check that you'll need to do, as well as other checks you might want to do. The biggest issue is whether you have to refund the holding deposit or you can retain it. There are various reasons for being able to retain it, but the default position is that you must refund it unless you have reason to do otherwise. There are what I call the two rules of 7, and that is you have to refund the holding deposit within 7 days of the tenancy starting, unless the tenant has agreed it can be withheld as part of the deposit or rent. And you must explain why you are not refunding it if that is the case. If you don't write to the tenant, the default under the Tenant Fees Act is that you must refund it, even if you had good reason to withhold it. So please bear that in mind. I can see someone's just typed in a question. Okay, so they have a tenant who lied about his income, and they want to know whether they have to still refund the holding deposit. Now, the government guidance is quite clear in that if the tenant provides false or misleading information, which they should reasonably have known was incorrect, that will be a reason for retaining all or part of the deposit. You will have to judge whether it is reasonable to do so. So please bear that in mind, but you may be justified. Okay, so let's now move on to deposits, which have also changed in terms of the rules since the Tenant Fees Act. We all know about the traditional tenancy deposit schemes, My Deposit being one of them. And we also are aware that there are a number of alternative schemes out there now that provide a rent or guarantee, a guarantee or a bond which covers the landlord up to a number of weeks rather than taking the traditional deposit. The Tenant Fees Act has changed the rules slightly, or clarified the rules, if you like. You can't just offer an alternative product only. The tenant must be given the option of the traditional deposit as well. And then it's up to the tenant to choose, because the tenant is going to have to pay for the product. What it doesn't do, as far as disputes and negotiating on any deductions at the end of the tenancy, is change the need for the evidence. So it's really key to think about what you need to keep from the past that might affect the future. Okay, so let's have a look at these deposit alternative schemes that we're talking about. Why are they a good thing? It's much cheaper for the tenant. He doesn't have to find the deposit as well as the first month's rent. He might also be waiting for the deposit to be refunded from the last tenancy. So there's a lot of money that ties up that a tenant has to find to start the next tenancy. This is a tenant product. The tenant pays for this product, and it is used to give the landlord comfort, knowing he is covered for a number of weeks' rent depending on the product that they buy. The good thing is that there's no interaction with a scheme. If there's no dispute, they can move on, and there's nothing more to do when the tenancy comes to an end. The biggest positive for landlords and agents is that their property might appeal to a wider market. So it might become more affordable for tenants to choose a property where they can afford the rent, but maybe not the deposit on the top of that. So very often the premium for the deposit alternatives is a lump sum, like an insurance product or a monthly fee. So sometimes that is quite a big pull for tenants as an option. So let's think about the challenges to these products though. The tenant has to find the money for the deductions at the end. He's paid for the product, but that does not give him any cover in terms of money for damages that he may have caused during the tenancy. If the tenant doesn't pay, it can lead to him having a poor credit rating. So the tenants need to be very aware when they're buying the product what the consequences might be of not resolving issues at the end. The tenants are more likely to challenge this kind of product that may be under the traditional deposit because they have to find the money. Whereas with deposit deductions, very often they will accept a small fee and let the landlord keep some of the deposit to then move on. The biggest concerns in the industry are around the clarity of the tenant's awareness of the product itself. Are they actually aware of what they are buying? Has it been transparently sold to them? Has it been the only thing that's been sold to them? Do they understand that they're paying a price, but it doesn't cover them for the damages at the end? So these are all the things that are being looked at by the powers that be in the industry. And the landlord still may have to pay for the damages to be rectified for the next tenancy to move forward until the claim is settled by that tenant. So there may be a delay in that. So it might not be a quicker process than the traditional deposits. Okay, so we've touched on things that need to be done before the tenancy starts. I just want to look now at the first document that we talk about when the tenancy starts, and that will be the tenancy agreement. It's really important to understand your agreement, to know your tenancy agreement. Is it an old agreement on the basis that the tenancy started before the 1st of June 2019, or is it the new type of agreement after the Tenant Fees Act without any fees, any banned fees included? You should also know what your responsibilities are and have actually made it very clear what the tenant's responsibilities are. Every tenancy agreement now has to have that deposit clause. If you are taking a deposit, it has to make the tenant aware that the deposit has been taken. It's clear to both parties that it's protected and in what circumstances it can be withheld. You also need to remember that to add any clauses which might be discretionary, non-mandatory, if you're allowing the tenant to keep a pet in the property, or if you don't want the tenant to keep a pet in the property. So you need to remember to make sure the clauses are there for them. When it comes to responsibilities, as I've already mentioned, it's really important to lay these out in plain and simple English. When I do lots of these workshops externally, I often ask whether tenants are, whether people deal with tenants that are not English speaking, and nearly everybody will put up their hands. So even if the tenant doesn't understand the contract, they should be able to take it somewhere and have it easily explained to them. And of course, you need to be aware of the Tenant Fees Act. You need to be aware of whether your contracts are of the old kind because you haven't got a new tenancy that started since the 1st of June, or whether you need to think about updating your contract. So just be very aware around the Tenant Fees Act and what fees are actually banned. It's also worth remembering that this is quite an undervalued tool when it comes to negotiating with the tenants at the end of the tenancy on any deductions. You can remind them then of their responsibilities. It should be the starting point for negotiation. It's also worth reminding landlords and agents to remind their landlords, if I've got any landlords listening today, that landlords are not responsible for wear and tear. So where a tenant might cause damage and even accept some damage, it's not for the tenant to replace the item at the full cost. There will still be some wear and tear there. So please bear that in mind when looking at making deductions and negotiating with your tenants. The other documents that are really important when we talk about negotiation are the inventories, the check-in, check-out reports. We can use inventories just as a short form for referring to all of these. Why are they so important? Well, if you have no inventory, what are you going to negotiate with when the tenancy comes to an end? There is very little detail of anything, and as good as your checkout will be, you cannot show the extent of any deterioration. I just want to very quickly highlight three very loose exceptions to that rule, though. If, for example, you have, if in the event that you don't have an inventory, but you have invoices for an item or an area that was newly refurbished at the beginning of that tenancy, please keep it. Please understand that you can use that to negotiate. That is good evidence as that the item or the area involved was new at the start. If the property is a new build, would be another exception to the no inventory rule. You may have a claim depending what is damaged. If the item or area would reasonably have been new at the start and it goes to a formal dispute, or you want to negotiate on it, then please think about what you're claiming for. And the final exception to that rule is where the tenant makes an admission. If the tenant makes an admission, then he should be prepared to offer compensation. When it comes through to an adjudicator, we will take that into account. But landlords, please be aware that you're unlikely to get as much as you might be asking for because you have no inventory to show the exact condition at the beginning. Okay, detail is really important on an inventory. Just having a tick box will not be enough. Leaving tenants to fill in a form by themselves will not be enough. These are all the kind of things that we do still see. So be very clear in your detail, your written description, have good quality photos. I just want to highlight the fact that sometimes there are photo and video inventories out there, which we do get sent when to adjudication. They must be of excellent quality to be of value. And the one thing I will say about video and photographic inventories is that they can be excellent if the quality is good on showing the difference in condition of something, but cleanliness is not easy to show just by photographic evidence. So I would encourage anybody using these products to make sure there is some narrative on the standard of cleaning in the property at the time. The next key point on inventories is to understand the difference between the cleaning standard recorded in your reports and the condition of items. Let me give you an example. If your tenancy is a 5-year tenancy, and you can appreciate that the condition of your property is going to deteriorate over that length of time. However, a tenant who is given a property to move into cleaned to a professional standard will still need to return the property clean to a professional standard. So what that means is that fair wear and tear will apply to the condition of that property over that period of time, but it won't apply to cleaning. So make sure you very clearly define the difference between the two. And finally, no matter who does the report, as far as decision making goes, as long as we can see that the tenant has seen it and had the opportunity to comment and make any amends at the time it was done, then we are happy that it's a valid report. The reason I'm mentioning that is a very common question is, does it make any difference who prepares those reports? And the answer is, from a decision-making process, the answer is no. So what I would say is, inventory companies, third-party inventory companies are obviously qualified and produce very good reports, but there is no reason why a landlord or an agent cannot produce a detailed report themselves. Okay, I can see I've got a question here about damages and cleaning. And they've just asked the general question, what is the most common issue that adjudicators deal with? Now, the biggest issue for us is cleaning, which is why I've stressed the need for cleaning to be very clear, clearly described in writing on your reports. If you have cleaned the property before the tenant moves in, provide the tenant with a detailed invoice, or at least attach it to that inventory so you've got something to show the tenant at the end. Yeah, I think that's really important to do. Cleaning is very subjective, as we all know, so I can't stress enough the need to have that detail on the reports. I hope that answers that question for you. Let's move on. So we've talked about all the things that are in the so far during our tenancy journey. These things are all in the past. Your tenancy is now ongoing. You may have taken a holding deposit. You may have taken a deposit. We've dealt with the tenancy agreement, and we've talked about inventories. But it's really important that during the tenancy we think about not only the future, we remember the past, but think about the information which could be gold dust from the past and into the future. So I want to think about some other things that may crop up during the tenancy that become relevant to the end. We want to stay ahead of the curve, so you should always be aware of what the new rules that might be coming in. There are some regulations that we know about that are not in the not too distant future. You need to also be aware of your tenancy end dates. Are you intending to allow it to go into a statutory periodic, will be quite relevant to the Tenant Fees Act, or are you going to have to think about the new style contract if the tenancy started before the 1st of June? So how have things changed since your last tenancy started? The next thing to think about is keeping good records. It's key at the start, before the tenancy, at the start and during the tenancy. Are you replacing items, or have you done something to your properties at the start or during the tenancy? Make sure you keep these receipts. This is one of the most frustrating things sometimes when we are making decisions and adjudicating, that we don't have the detailed receipts or the receipts that would help the landlord with his claim. You also need to be able to show them to the tenant when you're negotiating, or provide them as evidence in adjudication, and they should be as detailed as possible. If for some reason you didn't do an inventory, then it's never too late, and this is always a message I give to agents in particular who may have acquired a property from a landlord who can't look after it themselves anymore and may not have had an inventory. I think it's always worth going to do a property visit and recording the condition of the property at that time, particularly where the tenancy is ongoing and there's no end in sight. So maybe it's going to be another 2 or 3 years, and you can then use your property inspection report as a starting point for a discussion. It's also worth mentioning that in order to maintain and keep a good relationship with your tenant, you should deal with things as and when they happen. So it can diffuse any situation if you can agree to repair something. The tenant may be willing to make a contribution if he's accepted some responsibility, but don't leave these things till the end of the tenancy when they can escalate because there's more than one issue to discuss. So these are all things just food for thought, which leads nicely into what is coming down the line. What do we all have to know about? What do we have to be aware of? We've already discussed the tenant fee ban. If your tenancy started before the 1st of June 19 and is now ending or is being renewed, then you'll need to have the new tenancy agreement to hand. We touched on holding deposits as well. These all come under the tenant fees ban. The guidance is on the government website, and if you need a link, please ask us and we will send it to you. The statutory periodic will be the only exception to the Tenant Fees Act, but we are currently in heading towards the end of the transition period. And what that means is that fees which were, so currently in the transition period, which will end on the 31st of May 2020, fees on old tenancies started before the Tenant Fees Act came into being were still allowed. But what happens from the 1st of June 2020 is that all banned fees under the Act will take effect. So this becomes retrospective and not just on new contracts. So please be aware of any fees you may have in your old tenancy agreements that you won't be able to apply. The new EPC rules are very are on us now. The new EPC rules required all properties to be E-rated from 2018, which was only on new tenancies. And from April 20, this now becomes retrospective and all properties have to be E-rated. This is causing some problems in the industry for landlords who are having to rush to get their properties up to scratch, but they have had 2 years to do it. So we'll be looking at the property press and keeping our eyes on this. Make sure your EPCs are up to date, please. The newest thing that has been in the press has been the electrical safety standards. This has been talked about for some years, has been very topical with Grenfell, but from April this year, we're talking about, we're waiting for the regulations to be implemented. If they are implemented, what I wanted to do was just run you through how they will, who they will affect and what the effect will be. So it will only affect private residential tenancies, and it will only apply from to new tenancies from the 1st of July this year, so 1 month after the end of the tenant fees transition period. It will then become retrospective for existing tenancies from April the 1st, 2021. The proposal is that all electrical wiring and fixed installations should be checked and a report provided and signed off by a qualified electrician. The report should be shown to tenants at the start of all new tenancies and renewed at a minimum of 5-yearly intervals. And that will be dependent on the new tenancy starting and any electrical or fixed electrical installations sorted during those tenancies. The important things for landlords to understand is that if the landlord is required from the report to do some work and doesn't remedy the issue within 28 days or sooner, depending on what the recommendation is, the local authority may be informed and the council will have the power to issue a fine of up to £30,000. So please bear that in mind. Keep your eyes and ears open for those regulations to be implemented. The final thing, Section 21, the notices to end the tenancies. This has been on the government agenda for the last couple of years. They've looked at it. It's definitely going to happen. It was in the Queen's speech in January this year. It's definitely on the government agenda, but obviously other things have taken priority. It's likely to take some time before this happens. The government need to look at, and the industry is recommending that we obviously have a housing court in place that can deal with all of these, because it will mean that there are more cases that need to be heard. And we're also looking at how to bolster and add to and improve the Section 8 eviction notices. So there is a lot of sensational press out there. I think it's really important to understand and put it in perspective. In Scotland, they have no fees to tenants. They have no end fixed dates on tenancy agreements, and there has been very little repercussions on this at all. So I think it can work with the right infrastructure in place to support the new Section 8, but it needs to be thought out properly and thoroughly. Okay, so what do I want to add to the information I've given you? Today has been an overview of the past, the present and the future for you. As this has been our first webinar, we would really love to know what you want to hear about in the future. We will have more webinars throughout the year, so watch this space, please. We will provide some more detailed webinars on each of the topics that we've discussed today. So we'd really appreciate good feedback as to what you would like more detail on. If you're on our mailing list, then you will automatically receive our newsletters. But if you are not and would like to, just ask in the question box and we will sort this out for you. It's worthwhile remembering that we also publish new monthly case studies on our website and on social media. So if you would like to see this, you can follow us at My Deposits on Facebook, Twitter and LinkedIn. Okay, I'd like to say thank you very much for listening. And if there are any more questions out there, I will have a look at those now. Okay, well, I think that's it for today. I can't seem to find any questions in all the comments that I've got coming through. Thank you very much for listening. I hope you found it interesting, and I'm welcome your feedback.